We want to bring in constitutional law attorney David Coale for more context and perspective about the real world implications here. Thanks so much for the time.
Thank you for having me.
What stands out most to you from your legal perspective about the ruling and the dissent that we've both gotten in the last few hours?
Well, what's interesting, on the surface, everybody agrees that you don't want to have racial animus, racial discrimination driving the preparation, the drafting of congressional districts. Everybody agrees on that. Where the difference is, where the rubber hits the road, is on how do you prove that. And the majority says, look, we're not requiring that you actually have to prove what's inside somebody's head, that legislators acted with discriminatory intent when they created something like the Louisiana map without this new district. But the standard they set up for the effect that you have to show looks an awful lot like trying to prove intent. And so by sort of changing the standard, you've created a situation where it's very difficult to justify the creation of a new congressional district simply to give minority voters an additional voice in the process.
Yeah, critics really saying that they feel like this would make it much harder, specifically for Black or Latino voters, to challenge maps that dilute their voting power here. And this is a conversation we're seeing all over the country right now. I'm thinking about Texas and California and beyond.
Yes. Right. I mean, and it's the battle that's going on across the country right now is it echoes a lot of things in this opinion. The opinion says it's okay for a legislature to consider politics when it draws lines. You can try to keep incumbents in their position because that's what legislators do. They're political bodies. But what the Supreme Court said here is if you're going to challenge that based on race, you have to factor out all of those political considerations as well as the fact that Democrats tend to draw more minority support than Republican candidates, to where you have left behind something that's clearly attributable only to race. That's a hard burden. That's a hard thing to do because we all know in the real world, a lot of different motivations kind of get squished together. So it becomes a lot harder to make a claim of racial animus in that circumstance and in these situations across the country.
Here we are. I'm in Atlanta here in the cradle of the civil rights movement, home of the late Congressman John Lewis, who, of course, was on the Edmund Pettus Bridge fighting for this voting rights legislation in the 60s and then served Georgia's 5th Congressional District for 17 terms. So there are two sides of this conversation here. I'm curious to get your input. One that says this weakens the Voting Rights Act, but another saying it just clarifies the limits. Where do you fall on that, and how should people be looking at not just the decision today, but the movement, kind of as we've seen challenges in many cases now to the voting rights legislation that was specific to 1965?
There are a couple of things there that echo more broadly outside of this case. One of the points that Justice Alito makes in his majority opinion is the world has changed. The world doesn't look the way it did in the 1960s when this law was passed, and a lot of the just grotesque segregation that existed in the 50s and 60s has gone by the wayside. And that point certainly has force. What has the force Justice Alito gives it is a matter for debate. Relatedly, Justice Kagan points out in her dissent, wait a minute, we dealt with this. We didn't, the government did. Congress dealt with this 20 odd years ago. It revised the Voting Rights Act the last time our court came out with a new test that made it harder to prove racial animus and made it easier. So I think, Justice Alito, that your opinion is contrary to what Congress intended to do when it wrote the rules in this area. All of that leads to this, that the courts are a little more hands-off than they might have been a few years ago. And if people want to pick up the mantle and try to create something that's more aggressive in this area, the solution is going to lie with Congress and perhaps state legislatures. The courts are just going to be less active than they've been historically.
Because now, correct me if I'm wrong, it kicks down to the lower courts.
Well, yes, it goes back. This case came up from a three-judge panel. It's a unique thing for voting rights cases. I guess it goes back to them, but the Supreme Court's kind of told them what to do. So there's not a whole lot left there. But where it has effect in the lower courts, like right now, is in ongoing litigation across the country about similar issues, some of which have come out of this recent spate of redistricting, some of them just been simmering for a long time. In all those cases, both sides are going to have to step back and look at what the record in their case really means in light of this new standard the Supreme Court has come out with. And some of those cases may end up getting dropped or dismissed as a result of this because it's clearly harder to prove.
Where do you think we go from here? What do you see as the next step?
Well, you're going to see districts kind of stay where they are, I think, because they've sort of reached a steady state, and trying to add new districts in the name of more racial equality is going to fall by the wayside. Conversely, if I want to add a bunch of districts for some partisan reason, I want more Republicans, I want more Democrats, it'll be harder to put up obstacles to that in the form of arguments about racial effect. So I think you're going to see that in the litigation. On the political side, particularly if the Democrats take control of the House, I think you're going to see some revisiting of the Voting Rights Act to respond to this and say, well, maybe we should change the law to do this, this, and this to change some of the things that bothered the Supreme Court in this opinion. So you'll see activity on both branches of government there, the legislative and the judicial, trying to fully reckon with what this opinion tells us.
Yeah, I guess we come full circle as you and I kind of started at the beginning talking about how big of an issue redistricting is. And both parties really see that as a potential way to get a leg up. And we don't expect that to stop anytime soon. So this conversation is, I guess, to be continued, no doubt about it, huh?
Is very much to be as long as you've got legislators that come from different regions, there's always going to be dispute about districting. And here, all we know for sure is that the courts are just going to have less to say about that than they've had the last 20, 30 years.
All right. Well, we really appreciate your insight and your knowledge and helping us kind of digest this landmark case that has just come down from the Supreme Court. Thank you so much, and look forward to talking to you
Thank you
again.
very much. I appreciate it.
Take care. Thanks so much.